think it's for me to speak. So I'm speaking, only seeing some faces on the screen, but I know there's a very large number of people who can see us. So welcome everybody. This is the launch of a new book by many contributors who you're going to hear from, AI and Autonomous Shipping, Developing the International Legal Framework. My name is Simon Pickin. I'm a judge of the Commercial Court. At the moment I'm wearing this because I've literally just run out of the Court of Appeal, where I'm hearing the post office appeals, which you may have heard of in the press. Now, without more ado, I'm going to get cracking on to the introduction for each of the various contributors of the various chapters of this wonderful new piece of work. Just may I make this observation that some of you are in Wales, and I've just spent 10 weeks in Wales doing the Barry Docks murder trial. But you may notice that your contributors on the screen are distinguished between those who are in Wales and therefore have been able to have haircuts in the last week or so, and those in particular, Mr. MacDonald Eggers, Queen's Counsel, who is in London, and you may see that his hair looks a bit unruly. He, of course, hasn't had the advantage of coming to Wales lately. But anyway, let's get cracking. I wonder if I can first just introduce Ms. Roberta Bassi, who is a representative of the publisher of this book, Hart Publishing. And I wondered if I might just ask you, Roberta, maybe a question or two, if that's all right. And perhaps the main question would be, how do you see this book fitting into the publication ethos and priorities and indeed values, I guess, of your company, Hart Publishing?
Well, thank you very much for having me here today, and it's a real pleasure to be participating in this event. I have to say I'm the commissioning editor on the commercial law list at Hart more generally, and I have to say we're absolutely delighted to be publishing this book. Shipping and maritime law are subjects on which we would like to grow our list more. We obviously have a very strong presence in the world of private law, in the world of EU law, for example. In commercial law, we're trying to make a name. We've been trying to develop the list more in the last 4 to 5 years. And, maritime and shipping law are topics on which we would very much like to grow the list more. So we're absolutely delighted that Barish and his team have decided to come to us with this wonderful project. And we think I think that the project is very much, a reflection of the kind of books that we like to publish, where, you have a strong, cohesive voice throughout, the entire book, even though every individual chapter is written by a different author. You can really see that there is a strong project at the core of this, and that the contributors have, of course, participated in and sort of exchanged ideas and sort of discussed with each other before coming to the final product. So I really hope that everybody will enjoy the book.
Thank you, Roberta. I think it's fair to say that quite a few of us, perhaps even on the call, have spent our whole careers trying to make a commercial name. So good luck for Hart Publishing. But tell me, why particularly this book dealing with AI and do you have a particular interest in technological developments, I guess?
Yes, absolutely. And I think that it's very clear that AI and the Internet of Things more generally are having an impact on the law, broadly speaking, and we are trying to reflect this in the kind of publications that we are doing. So if you look at our list at large, we've actually been looking at how AI has been impacting on a number of different areas of the law, from AI and the legal profession to more philosophical questions as to whether law itself is computable. We just published a book on this topic a couple of months ago. And why not the topic of autonomous shipping and the law, how the two combine? I think that there is a whole realm of questions in terms of regulation and in terms of how does the AI really fit in that need answers. So for us, it's really a growing field, and one in which we are keen to see more books published.
Thank you. Thank you very much. That's really very interesting. Barish, can I turn to you, do you think? And can I ask you, how did you go about approaching the various legal issues concerning autonomous vessels, which you've addressed in your, in the book? You need to unmute yourself and you will pay a fine.
Thank you, Simon, and I apologize. Absolutely. When one starts considering the issue of how new and emerging technologies need to be regulated, naturally, the first port of call is to consider to what extent the existing legal rules and regulations could accommodate the development of this new technology. This was the starting point for the scoping exercise that is currently undertaken by the IMO on the same subject. It was the starting point of several academic work produced on the subject, and it was our starting point too for the book. But what we try to do in a nutshell in the book is, in the first part of this book, we considered legal rules concerning safe money and navigational vessels, which are mainly found in IMO conventions such as SOLAS, MARPOL, and STCW, and to what extent they can accommodate the development of vessels that have remote control capability and also vessels that can navigate autonomously. We also, in the light of the Law of the Sea Convention, discussed the rights and obligations of flag states and coastal states when it comes to the cooperation of such vessels, particularly outside the territorial waters of a state. Of course, we are private lawyers, so naturally, we also engage in a detailed elaboration on how private law rules on salvage, limitation of liabilities could cope with this new type of autonomous vessels. We believe, particularly this one is a very interesting analysis, not because it's been written by Andrew and me, but we believe that so far the discussion is focused on the public aspects of the issue, which we do cover as well, very ably by Simon and Yuri in this part. But we think that this is actually quite a new dimension, and it's probably somehow ignored dimension. So in the first part, we look at the existing rules and see how they cope. In the second part of the book, we try to take the debate further by considering the new issues that we expect will emerge, particularly in the private law sphere, when autonomous ships become a commercial reality. For example, there is a very interesting analysis offered by a leading tort lawyer in the shape of Professor Bakshaw on the product liability issues. We also considered the impact of cyber risks on the liability of ship owners in a chapter which George took. He discussed whether adjustments in the current liability regime should be necessary as a result of the cyber element of the debate. And of course, no debate on liability is complete without an analysis on insurance matters. And we were lucky enough to have a leading expert in the shape of Peter McDonald, Eggers QC, who actually offered a very illuminating analysis on those issues as a concluding chapter in part 2. So in part 1, we looked at what the law is, how it copes with it. In part 2, what other issues we think will come up. And in the part 3, we try to bring all this together by considering the mechanics of a potential reform that need to be carried out to make sure that autonomous ships and remote control ships can become a commercial reality. But I suppose that would be enough on my part at this stage. I think individuals could say more on what they've done and what they covered. But in a nutshell, that's the general framework of the book.
Thank you, Barish. That's a very interesting overall introduction. And I should have said, by the way, that this seems to me at least to be another area where your institute at Swansea University is leading the way. And I've told you before, because although it may not be apparent to others, I am Welsh and proudly so. And it's nice to see, even if it's Swansea, when I come from Cardiff, Swansea doing so very well. So let's now look at the individual contributions. Yuri, if I may, you're dealing, or you've dealt in the book with aspects of the public maritime law regulatory issues. And I was wondering, what are the main issues that you, from your perspective, need to be resolved from the perspective of the 1982 Law of the Sea Convention to ensure that autonomous vessels can operate smoothly at sea? Obviously, you mustn't say too much or nobody will buy the book, but if you could just give us an overview.
Yes, thank you for the question. Indeed, there are several potential issues that might arise, but I will only highlight some of these issues. If you look at it in a general sense, well, this introduction of autonomous technology in shipping, what prompts questions around how can such craft be accommodated under the International Law of the Sea framework? And especially, how can they be brought under those provisions which are seemingly preconditioned on vessel status or presuppose the existence of an onboard master, officer, and crew? Well, there are different views in general over whether to bring autonomous cargo craft within the scope of application of those parts of the Law of the Sea Convention which deal with international shipping. And if you look at this range of opinion, you will see that some say that they cannot or ought not to be incorporated under Law of the Sea Convention. Others say that they clearly meet the definition of a vessel, or at least that they probably have to be considered vessels. But no matter how one actually precisely values these difficulties, with regard to the introduction of autonomous technology in transporting cargo, at a minimum, it is clear that if you look at the Law of the Sea Convention, and if you analyze the language, you will see that the language is susceptible to different interpretations, and each camp is able to invoke reasonable reasons in support. And these different views over, for example, the status of autonomous cargo craft, these might also be mirrored in the positions of states, whereby at the same time, the possibilities of disputes arising between states, the coastal state and the flag state, for example, is laid bare at the same time. Well, of course, at the heart of all these difficulties lie that maritime autonomous craft that are used to transport cargo challenge a preconceived understanding, and that is that a merchant vessel carries a master and a crew on board in order to be able to operate. And this was also the guiding thought on the mind of the drafters of the Law of the Sea Convention. And at the third conference, they were, of course, dealing with manned vessels. And I think these beliefs also seeps through the language and context of the Law of the Sea Convention. Of course, you have the issue of to what extent the text of the Law of the Sea Convention must be read in a way that pace is kept with the introduction of new technologies, because the argument is otherwise it will become redundant. But leaving that further aside, once it is assumed that a seagoing craft is a vessel, it has navigational rights and freedoms under international law. But accompanying these rights are also certain obligations, and these obligations have to be shouldered by the flag state. But when some of these obligations are applied to autonomous cargo craft, you run into difficulties, and particularly those difficulties, for example, arise in connection with Article 94 of the Law of the Sea Convention. One obligation is that under Article 94, paragraph 4b, each flag state must ensure that its vessels have a properly qualified master, officers, and not or a crew. And I would argue that based on an ordinary reading of this text, they ought to be based on board. I think I will leave it here. There's much more to be said, as you correctly mentioned, but this was just a teaser with regard to the issues that do arise. Thank you.
Thank you, Yuri. And as I say, you don't want to say too much because you want to keep people on the edge, as it were. But I wonder, can I come on to Simon? I can't actually. Oh, there you are, Simon. Hi.
Myself. Yep.
So, can I ask whether you, from the perspective of other international public law instruments, such as SOLAS, for instance, what would be your main conclusions in relation to AI?
I would say, first of all, there are some fairly obvious regulatory problems. There are some, I think it's probably MARPOL, but there's one of the IMO regulations talks about the construction of ships and which presupposes a physical bridge. And I think that's something which should be addressed and presumably will be addressed. What I'm more focused, there are two things. First of all, there's masses of references to master and crew. I think we could solve that. Somebody in command of the ship, well, that could be shore-based controllers. I mean, I don't think that's too difficult. I think what needs to happen, and I think will happen, is first of all, the development of qualification and training standards for people who are going to be operating ships remotely for onboard controllers. And I think until we get that, it's going to be very difficult to talk about, properly qualified master and crew. I mean, what is the qualifications? At the moment, there are no qualifications for, well, there aren't even any SBCs at the moment, unless the Yara Birkeland has already started sailing. So that's one thing. And I note that the EU has produced some guidelines as to testing of autonomous vessels. And one of the things it's suggesting about the people who are going to be shore-based controllers, they should have the same qualifications as people on board a ship, and presumably they ought to know how to operate a computer as well. But I imagine that that's not going to be a problem. So, and I think that might be the way things go. That we have to work out training qualifications. The second thing is, at the moment, I don't see any standards for navigational software, and I think we're going to need to get that developed and hopefully get some sort of reasonable coordinated platforms. We're not going to sort of have the sort of VHS and Betamax sort of replicated hundreds of times over, or Apple and Mac. But so I think it's what we haven't got, which is going to be a problem, and it's something we need to develop. And I would say that port states do have the right to refuse entry to vessels, and I imagine that port states may well refuse to allow autonomous vessels in until these issues have been dealt with.
Thank you very much, Simon. It would be a slightly disturbing prospect that there might be onshore operators who can't operate a computer. But anyway, we'll make the assumption you've made.
Yes.
Thank you very much indeed. Can I come on then to the sort of the second section, as it were, which concerns the private law issues, private law maritime issues. And I think, Andrew, can I ask you, Andrew Tettenborn, from the perspective of private law, collision, salvage, that sort of thing, what would your main conclusions be, as again reflected, no doubt, in the book? You need to unmute. Yeah.
Actually, it's rather a surprising number of things that we might need to worry about. One thing that didn't strike me when I started doing this, of course, was the law of collisions. Now, you might have thought that, the law of collisions is basically the law of tort, and the law of tort is unaffected by the fact that you're dealing with computers. But it does tend rather to upend the law of collision, if only because once you've got a ship which is being navigated virtually wholly by AI, you immediately face the problem that there's no such thing as a negligent computer. So theoretically, the only way of getting at a vessel which causes a collision through a maneuver which would otherwise have been negligent is by getting at the guy controlling the computer. But that itself raises further difficulties, because you might then say, well,
Andrew, we've lost your voice, Andrew. Andrew?
well, should a collision between a man, sorry.
No, don't worry, we lost your voice, but we're going to assume you were just filling in time. So you can.
Of course.
Yeah.
The silly question to ask is, when did you lose my voice? Which, of course, is the time you never heard me say anything.
And it would also require me to have listened. But I was listening, I promise. No, seriously, just carry on, Andrew.
But anyway, no, the point about collisions, and there's no such thing as a negligent computer, which raises all sorts of problems. Could you introduce an element of strict liability? I'm not keen on that, because it would raise enormous difficulties if, for example, you had a collision between a manned vessel and an unmanned one, when one would be strictly liable, the other would apparently be liable for fault. The other difficulty with strict liability is, of course, it's not allowed anyway, at least not without a change in the convention regime. Most people don't take the 1910 Brussels Collision Convention to bed with them as an aid to sending them to sleep. But if you look at it, actually that does prohibit any element of strict liability, or for that matter, any element of reversal of the burden of proof. And certainly one conclusion I came to was, if you're going to do anything about this, you might have to look at the 1910 convention. But it's not only that. Salvage, again, you might have thought that was fairly immune to change, except for two things. Can you count it as marine salvage if you have a computer geek who sort of presses a few buttons on land in Milton Keynes, thus enabling a ship to be rescued somewhere in the middle of the Pacific Ocean? You know, does that come within the normal meaning of salvage, and can you squeeze it into the Salvage Convention 1989? You've also got a minor point, who's the master of the ship, because remember, the Salvage Convention has quite a lot to say about who has the power to bind the ship owner to a salvage convention. Carriage I'll leave to Simon Bourne, because I think he's dealing with that. The other point, of course, is limitation, which we're going to have to think about. Because we're going to, it seems to me, in practice, we're going to have a look at the LLMC. Because if negligence liability gets shifted from the guys on board the ship, because there aren't any, to the guys on shore, of course, bang goes the right to limitation, because however widely you limit the, however widely you read the London Convention, the 1976 Convention, as far as I can see, it doesn't cover a nerd sitting in front of a computer screen, somewhere in sort of Milton Keynes or Mumbai. And arguably it should, because otherwise limitation will essentially disappear in a puff of smoke. But anyway, that's the sort of issue we deal with. It's not quite as obvious as you might think, but it's actually highly important. I'll probably leave it there, taking your advice that otherwise everyone will just say, well, they've had the book for free, so they're not going to buy the damn thing anyway.
Thank you, Andrew. And I mean, you've raised some fascinating issues there, I must say, and issues which I suggest probably will transcend the strict subject matter of this book, actually. And that's, so I do look forward, in fact, to studying your chapter and seeing the ready answers.
Sorry, can I just barge in, because we wrote that chapter together, and I must say that it was interesting because we didn't agree all the time. So you will see that there is a compromise in the chapter when the book comes out.
I know what it is to co-author a book, and Peter always prevails. Anyway, Simon, back to you, if I may. Can I just ask you then, Article 3.1, which I'm sure everybody does take to bed with them, to take Andrew's example, of the Hague and Hague-Bisbee rules, imposes, as many of us will know, an obligation on the carrier to take due diligence to ensure the vessel is seaworthy before and at the start of the voyage. How do you see that obligation, by way of an example, operating with an unmanned cargo ship?
Right. Well, this is one of the key issues which had to address. And first of all, the word carrier, the obligations under the Hague and Hague-Visby rules, they're imposed on carriers. And there's nothing in the rules to say that the vessel has to have a crew on board or not. So that makes life a bit easier. Second thing to remember is Article 3.1 imposes a non-delegable duty on the carrier. So his independent contractors, if they have failed to take due diligence, well, you know, he's failed to take due diligence. So that's important to bear in mind when we're considering the status of the shore-based controllers who he will be engaging, who will very probably be independent contractors rather than his own servants. With a shore-based controller, I think, you've got the obligation of seaworthiness. I mean, you've got to provide a properly qualified and competent crew. So I would suggest that you need to have your shore-based controllers properly qualified and competent before and at the start of the voyage. Slightly more complicated if you are going to be using multiple shore-based controllers on a long voyage. You may use 2 or 3, but I would suggest that for the ones which are being used for later stages in the voyages, the arrangements which you make should ensure that you're using competent and properly qualified. I go back to what I was saying in my first thing. Let's have some qualifications, properly qualified shore-based controllers. So I think we can fit that in. Where I start to find some problems is what about the problem where the ship is unseaworthy because of a defect in the algorithms? And to some extent, you can deal with this. Well, you ought to install proper computer software. You need to monitor it. You need to download all the updates. But there is the possibility that particularly self-learning algorithms may go wrong, and you may end up with an incident which causes cargo damage and may well cause extremely other sorts of damage. And where does the owner's duty of due diligence, clearly the ship would be unseaworthy if there is an undetected quirk in the algorithms, which somebody decides the ship is going to turn starboard when it ought to be turning port, and we have a collision. I think there's no problem if somebody can get the ship's unseaworthy, but can the carrier then show that he's got a defence, that he's taken due diligence to make the ship seaworthy? What could he have done to detect this flaw in the algorithm? Probably, if he's doing all the necessary checks, I would say not, and in which case he will have a defence. And that could happen with undetectable flaws in the physical structure of the ship. I don't think it would be a particular new problem. There may also be issues relating, which I'm not going to go into, but I'm just going to do a teaser on it, on the defence of nautical fault in Article 4.2a, and how that might apply both as regards fault of the shore-based controllers or defects in the algorithm system. So.
Thank you, Simon. I had a follow-up question, an unrelated one about product liability, but what I'm going to do, if I may, I'm going to move over to George now and then Peter, and we may come back to that. Is that all right? George, I can see you.
Yes.
Tell me, and it's nice to see you. Tell me, what would you say makes the management of cyber risks critical in terms of autonomous ships?
Yes, thank you. Thank you for the question, Simon, and thank you for everyone for joining us today. I think it's critical because cyber risks are an overarching problem. I think whether you are autonomous, you operate on an autonomous function, whether you are semi-autonomous or whether you are an automatic function. And the management of cyber risk is critical, first of all, because the whole autonomy of operations will rely on the cyber dimension. Essentially, the idea is that you try to remove the human element away from safety critical applications, because I think the presumption is that humans make mistakes, especially when they are on board a vessel. So we try to keep them on shore, and that will allow the vessel to operate in a more efficient and safer way. But at the same time, the problem that we have with cyber risk is that opens up another door of problems, which is essentially to prevent people from interfering now with the operation of a vessel. And I think that's what the shipping industry is waking up to, is that unlawful interference with the actual assets can be more of a problem as it were in the physical world. And that's why I think the IMO, as of January this year, requires the implementation of a risk management system, cyber risk management system, as part of the safety management on board vessels. Because the idea now is that we are past issues like GDPR regulation and so on, where essentially cyber risk was a problem for interfering with data that the company had in its headquarters, and selling data and access to data is also manipulation of the vessel and having the potential to cause property risks, property damage, and life damage, and personal injuries. And this is something that I think the shipping industry, unlike, for example, the aviation industry, hasn't come across in the same extent. Piracy has been a problem of unlawful interference, but at the same time, it's not in the spotlight in terms of every single operator. As we move to more automated systems, whether again full autonomy or quasi-autonomy system, unlawful interference will be an issue, and it will become more and more critical now to stop the interference with the assets. And I think part of the problem is that we don't know anymore where the perpetrator might be. Whereas in Paris, for example, there are parts of the world where it might happen, it might not happen, you can avoid them, and so on and so on. Cyber risks are borderless. And to an extent, it might be a terrorist, it might be a disgruntled employee, it might be, like someone said earlier, a geek that tries to identify whether can access a system. But the bottom line is that you need to create at this stage, at the stage of developing the systems, a situation where unlawful interference doesn't become a problem, where you don't have a cyber 9/11 to extend in the shipping world. And I think that, to an extent, reflects on the legal system. And my part of the chapter I wrote is that we are moving more to product liability, and I think Professor Baxo will discuss about that. But there's a bit of a paradox with the cyber risk management, and from a legal point of view, that software producers are not so keen to move into a product liability, because that would essentially open up significantly their exposures. And they would love to see more of a channeling of the liability for cyber risks to the operator. And this is the question that I answer or try to start discussing in the chapter, that can we fit product liability, or is the market willing to fit product liability into the regime of regulating cyber risks, whether it's in the shipping sector or other sectors, like, for example, the autonomous car sector, where there are similar problems? Or do we need to have special solutions about cyber risks, like maybe more of an insurance issue solution, like we have done in the UK with autonomous cars? Maybe a no-fault regime where software producers will contribute to losses as a way of socializing the loss. I know these are not necessarily very popular options at the moment, but cyber risks, and again, not necessarily related to shipping, but cyber risks as part of the transportation industry raise issues of accountability. And it's not as if you can identify the perpetrator always, or you can also bring the perpetrator to justice or get indemnities from the perpetrator, which leaves the debate: do we move to product liability, or do we channel against via the ship operator? And it seems that although product liability is the most common, let's say, solution, or the more sensible solution, software manufacturers are not so keen, and they will resist. I think, from what I think at the moment, they will certainly resist such a move. And this is something to think currently, but also in the future as we move closer to autonomous ship operations.
Thank you, George. Now, I owe Roderick an apology, actually. I attributed the product liability question that I wanted to pose to Simon. But of course, I've managed to jump over you, Roderick, and I feel embarrassed because you're actually in the middle of my screen. So anyway, Roderick, can I ask you the question I wanted to ask about product liability, which is, tell me, do you think autonomous ships are going to raise any special problems with regard to the application of product liability and the well-known legal principles? And apologies again. No
need for apologies at all. Well, as George just suggested, that one of the problems they raise is an ongoing problem, a kind of problem about non-physical products like software, and that's not one that's peculiar to autonomous ships. But clearly the non-physical components are going to be important parts of autonomous ships. And so the question of how specialized product liability regimes that were developed for physical products might apply to these digital components is an important question. And it's one that I think actually those reviewing the product liability directive in Europe have on their radar, if radar isn't now an obsolete technology. And that it's going to be something that probably there's some progress on within the next year. But two other things that I thought from what I did looked significant was that the specialist product liability regime that's likely to be what's looked to if an autonomous ship runs down one of these many cold water swimmers that there now are around the coasts of Britain, or goes into a quayside cafe or the like, that the specialist product liability regime assumes that a product producer produces the product and then hands it over. That autonomous ships, I think in particular, we should anticipate that actually there'll be a continuing relationship between a producer and certain types of ships where the producer is taking a role in updating or monitoring and potentially is going to have the capacity to physically change the autonomous vessel after the sort of initial delivery time. Now that ongoing relationship between producers and the product actually doesn't fit particularly well with the specialist regime that we have, because the specialist regime looks at whether safer products were available at the time it was put into circulation, looks at what level of knowledge producers ought to have had at the time it was put into circulation. And so far as there is some sort of continuing relationship, then, well, arguments will start being run that actually the product is kind of continuously being resupplied each time a little tweak is made to its engine using the virtual shadow or the like. The other issue that I thought is lurking in the background of a lot of the debates is that when it comes to applying any standard, a negligence standard or a defect standard, there's a big question about what information is going to be available to work out, well, why did the vessel choose to veer towards the cold water swimmer rather than away from it and the like. Now with autonomous vehicles, where this has been thought about a lot, I think there's an assumption that there's going to be a lot of data available, that vehicles are likely to be sort of connected to the cloud or the like, and a lot of data from those vehicles is going to be getting stored and is going to be available in working out what went on. In the case of vessels, which might not have easy data connectivity, how much data is being stored and where it is I think, an interesting question. And decisions about, well, you know, what is the minimum are decisions that I think are going to have to be taken in order to have the sort of investigations that would be necessary in order to continue applying fault standards or defect standards or the like. So those were three issues that struck me: the issue about digital products, the issue about continued relationships between producers and the product, and the issue about how much data is going to be logged and where's it going to be?
Thank you very much, Roderick, and apologies again. Which brings us to Peter, the hirsute one. Now, at the risk of wanting to plug the book that Peter and I write, which would be wholly impermissible, and therefore I won't do it, what of course I am now intrigued by is that the next edition of that, which by the way hasn't even started preparation, will of course no doubt have to have a chapter dealing with the topic of autonomous or AI generally. So, but Peter, let me ask you, a number of us on this call know an awful lot about the duty of fair presentation, otherwise known as the duty of good faith, or previously known as that. What impact do you see the introduction of autonomous vessels having on that duty of fair presentation on the risk? It's quite a big question, I appreciate it.
Well, it's a very good question, Simon. Thank you for asking.
A big question, I said.
I know, and I said it's a good question as well.
Well,
it's a good question because obviously all insurance contracts attract this duty to disclose material information, and that duty of disclosure is closely informed by what the assured, the ship owner, knows, and it's also informed by what the insurer knows, because you don't have to disclose something to the insurer which the insurer already knows, but equally you're not required to disclose something if you don't know it. Now, under the Insurance Act of 2015, in my view, and others may disagree, the duty of disclosure has become more broad in scope because it has, I think, a wider test of knowledge as far as the insured is concerned. So if you think about it, the issue about autonomous vessels and how they're obviously going to be operated by artificial intelligence or very advanced forms of computer and computer programming, that will increase the range of matters which ought to be disclosed. So if you look at the issue of actual knowledge belonging to the insured, and the insured will very invariably be a company, the persons, the individuals whose knowledge counts for that purpose are those who form part of what's called under the Act, the senior management. And the senior management are those individuals who play significant roles in the making of decisions about how the company's activities are managed or organized. But in addition to all the matters which concern the maritime nature of the vessel as an income earning asset and the perils to which it's going to be exposed, you will have to also add issues concerning the management of the assured's information and operational technology systems, cyber security and safety management systems, failures or breaches of those systems in the past, and of course its general cargo operations, security and information technology systems and how they're impacted. And for that purpose, you have to identify the individuals who have this information, not just the board of directors, but it may well be the heads of division or heads of department, and which could be an extensive range of individuals. But knowledge is not just limited to actual knowledge, it also encompasses constructive knowledge, which really includes, under the Act, information which the insured ought to know. That means information which should reasonably have been revealed by a reasonable search of information available to the insured, whether the search is conducted by making inquiries or by any other means. And this includes information held within the insured's organization or by any other person. Now, that's incredibly wide. So it may well require the insured to ask questions not only of their own employees, but also their external agents, but also service providers, people who are providing services in relation to IT and computer systems. It also may require them asking information from persons who either operate or host their AI systems. So that can be extensive. Now, of course, offset against all this, Simon, is the fact that you don't have to disclose something to the insurer, which the insurer already knows. And the insurer is not just taken to know things the insurer actually knows, but also which the insurer ought to know. But it's not as, when I say ought to know, it's not nearly as wide a test as it applies to the insured. It's a much more limited test. And essentially, it means information which is held by the insurer and which is readily available to it, whether the individual actually knows it or not. But of course, as far as these matters are concerned, much of the information will be held by the insured. But when risks and issues about AI and computer programs and the like become endemic to the type of systems and therefore to the vessels themselves, then there'll start to be a time when the insurers will be taken to understand and appreciate those risks in the same way that they understand and appreciate the risks attaching to a particular class of vessels they're insuring. And finally, one should also take into account the fact that the insurer will also have to and may ordinarily undertake searches on their own internal databases, but potentially also external databases. And an open question under the Act as to whether external databases come within the knowledge of the insurer, because as I said, the information has to be held by the insurer, and whether if you access an external database via a PC on the underwriter's desk, whether that's held by the insurer or held outside the insurer's organization is a question yet to be grappled with. But it's going to have a profound impact. Both the Act and also the use of AI on vessels is going to have a profound impact on what has to be disclosed.
Thank you, Peter. And I'm going to ask you a follow-up question, if I may.
Okay.
A related question, unrelated question, really.
Yes.
What extent do you think traditional marine hull policies are going to have to be adapted or reformed to cater for the risks associated with autonomous vessels?
Well, it's something's going to have to change because, of course, the way in which ordinary hull insurances operate, they're at odds, for example, with cargo policies, which often are all-risk policies. Hull policies are not all-risk policies. They'll insure against things like perils of the sea and, of course, the intramarine risks. But there is an expectation now, at least in the London insurance market, that if an insurer is going to cover cyber risks and related risks, they ought to declare whether they're doing so or not. And therefore, and I think there's a Lloyd's market bulletin to that effect, which came into operation last year. So that means if we're just looking at the traditional perils insured under a hull policy, of course, if the vessel is damaged or lost by virtue of rough weather or storm or hitting an iceberg or whatever it might be, that's going to be covered by perils of the sea. But what's going to be interesting is if a mere glitch in the AI system or the computer system causes the vessel to take on water, for example, will that still be a peril of the sea? And I have to say, I suspect it will be, but there'll be arguments to the contrary. And in addition, under the intramarine risk, you do have cover for loss or damage caused by latent defects in machinery and equipment, or machinery association and hull. And I assume that the computer systems will be treated as machinery for this purpose. I could be, and therefore they should be covered to that extent. So it may cater for it, but the expectation will be that insurers will have to start looking at these risks and providing express or cover or exclusions in relation to these types of risks. And will, for that purpose, have to take into account a lot of information which they ordinarily do not take into account when underwriting these types of vessels.
I mean, it's fair to say that the marine hull policies we're talking about are anyway of some vintage, albeit they get revised, and perhaps this is the time. Sorry,
that's true, absolutely. Although the beauty of peril of the sea is that they seem to continue and adapt to modern age.
Well, thank you, Peter. Make sure you get that haircut.
I will, when I'm allowed to.
Now, by way of conclusion, Barish, I mean, what are your conclusions generally? It's a very wide question, but maybe focusing especially on the future regulatory work that's required in this particular field.
Thank you, Simon. I think we devoted a very extensive chapter to discuss the conclusions. And of course, they're not final conclusions because we will have a lot of discussion on this going forward. But essentially, we argue that a different regulatory process for amending technical rules with regard to safety and manning requirements discussed by Simon and the others should be followed, as opposed to regulating the civil liability issues emerging from the use of such vessels. With regard to the former, the regulation on technical issues, we argued that maybe a code similar to a polar code that makes amendments in the key IMO conventions, such as SOLAS, MARPOL, by using their Tajid amendment procedures, might provide the optimal results in the shortest period of time. Of course, if we go along those lines, this will not only standardize technical requirements of such vessels, but also enable them to operate in international waters freely without any legal constraint. Of course, we also noted that there might be certain areas which we need to develop rules, such as construction, technological requirements of such vessels, remote control operation centers. I think that's a very hot issue. What kind of technical requirements they should have, and so on and so forth. Training requirements or people who will be actually appointed as remote controllers. I think these are issues which need to be considered further, and the current legislation, current regulations do not provide answers to these issues. So I think that code might need to address those issues as well. But when it comes to private law issues, our conclusion is that maybe we should consider going a different direction. Maybe there might be a need for a new international convention dealing with the liability issues. We are fully aware that achieving uniformity in this area might not be possible. There might be lots of thorny issues like the strict liability. I mean, with Andrew, I had lots of debates on this over the beer in Swansea, discussing those issues. We have different views on that particularly, but I think there are a lot of other issues which needs to be further discussed. But maybe that could be the way to actually regulate that area. I think there are so many empty-ended issues in terms of private law, including the issues which Professor Bagshaw covered in terms of product liability, where it comes and what needs to be done in that sense, that maybe we need to consider a new international convention in that field.
Let me jump in. It's a little unkind to do so, given that you kind of invited me. But that I think, again, what your concluding remarks have demonstrated, what I would say all of the speakers have demonstrated, and I genuinely look forward to reading the book, which I haven't yet done, that this is a challenging matter to have addressed in a book, but also a novel and exciting one. And so I personally would like to congratulate all of you. I have to go because I'm straight back in the Court of Appeal just across the corridor. That doesn't mean that everyone else has to go, but would you everybody excuse me, because I really do have to get back into the Court of Appeal. But thank you for inviting me. I congratulate everybody again, but if you don't mind, I'm going to have to just whiz off.
Thank you very much.
Thank you. Thank you.
I think if the leading judge leaves, I think it's for us to bring it to an end as well. There are a number of questions. I think we try to answer the questions to the extent it's possible. I think some of the questions we answered in my answer. Yes, regulation, different type of regulation needs to be done. Maybe Simon can take the ropes question at the end, and that way we can bring the proceedings to an end, answering at least one of the questions live, because I think the other questions either we answered in writing or I did cover in my last talk.
There was
Simon?
one actually which I think wasn't answered, which was Geoffrey Bloom's.
Please, go ahead.
Which was, what are we going to do about deliberate hacking? And what countermeasures might be available? And would the Navy make those countermeasures available to the Merchant Navy? I'm pretty sure that the Navy does have these countermeasures, because I have no doubt whatever that the Chinese Navy, among others, is well up in this sort of thing and has all sorts of devices prepared to make life difficult for any potential enemy's shipping. But I'm pretty sure that at least something would be done by the Navy, obviously without compromising secrecy, to deal with this problem. But it's a very good question, because this is actually a problem which in practice could affect other things. For example, the CLC, in respect of tankers, has an exception to liability in respect of the deliberate act of a third party aimed at causing that particular loss. Now, that could actually become highly important in the case of the unknown geek in Milton Keynes, and is another very good reason for producing defenses against the unknown geek. Anyway, sorry, Barish, I shouldn't have leapt in there, but it was a very good question.
No. I think we want to add. George, do you want to also add something? Because I see you waving your hands.
Yes, and I think that on the same question, I think the idea is that finally in shipping, that the ship operators take the potential interference with your cyber dimension more seriously, and this is why, as of the 1st of January, it's compulsory now to have and be verified to have a cyber management system on board the vessels, not just in your headquarters, to avoid the data breach, but also to avoid access to on board. But the problem you have, and I think that's reflects to an extent the discussion about seaworthiness under the Hague Visby rules and so on, is that IMO has given very loose guidelines, and I think there is no clear path as to how we are going to do that. And I think so ship operators take different views on what do we mean by cyber risk management system on board the vessel, which I think for the years to come, we're going to see to what extent we're going to have increased attacks on board the vessels and what kind of systems will be used and what will be the best practices to avoid that kind of interference. For example, what BIMCO has highlighted, a number of other researchers have highlighted, is that you cannot prevent denial of access attacks against the server of a vessel in the same way that you prevent similar attacks against a server located somewhere in the mainland. And you can't just copy paste land solutions when it comes to cyber risk prevention on board the vessel. So it's interesting from a point of view of a researcher, whether it's a legal or a purely cyber research. It's a very interesting time to go through this kind of issues, but at the same time, from a point of view of an operator, it raises questions about best practices, which at some point will be reflected on the legal regime, especially the Hague Visby rules. That's all. Thank you.
Thank you, George. I think we'll take two more questions, and there are two interesting questions. One is from Rob, a good friend. I think, Simon, maybe you're the best person to take this. How will the connection loss and interference, whether port crane structures, blackout on board, be dealt with? Any loss of connection during software update, whether on board or on shore?
Right, a very good question, which is always a question one dreads getting asked. But actually, what I would say is, what's the reason? What would be the reason for the blackout? I mean, I can quite see a possibility that you get blackouts which are due to the internet service provider. There's just too much strain on the internet, and that can particularly be a case when you're getting bad weather. Well, from the point of view of the ship, I don't think there's any fault involved on the ship or the ship owner's part in that situation, providing. If the internet goes down, you're in a bit of a pickle with your autonomous ship. That I would say would, from the point of view of the Hague Visby rules, it would be a defence under Article 4.2q. If on the other hand it's a problem with the ability of your ship to communicate, because there's something defective in perhaps the hardware, or the software itself on your ship, then that, I think you've got an unseaworthy ship. That's a bit, yeah. So I hope that goes somewhere to answer. Yeah.
Thank you. Roderick, if you don't mind, there is a conceptual question here with a historical context to it. For Ben, are there any parallels to be drawn, lessons learned from the transition to diesel engines? Presumably there would have been an equal concern about product liability there. Is that something you want to say something about?
I'm afraid that I'm so ignorant about the transition to diesel engines that I can't even tell you exactly what decade we'd have been talking about. But I've been, I guess, guiltily looking forwards rather than looking backwards. But I think maybe somebody else on the panel would be better positioned than me to talk about that particular transition.
Andrew, tort-related issues, we'll come back to you. What do you think?
I can't see much happening as a result of the transition from steam to diesel, except for the fact that diesel engines are probably slightly less likely to do harm under product liability law. But again, I'm open to correction there. In practice, of course, a great deal of the EU product liability law isn't going to be very relevant anyway, because remember, it only covers damage to people and to private property. It doesn't cover, unlike US product liability law, it doesn't cover damage to other ships or to commercial property. That's probably the best answer I can give, and I suspect it's unsatisfactory, like most answers you get in English law.
Thank you. Thank you. Of course, I would like to thank everybody who actually contributed to this, also the participants, for the questions. We should remember that we are at the beginning of this regulatory marathon. Time and energy need to be invested, and technological developments at the same time need to be closely monitored during the process of developing a new legal framework. And of course, one should not underestimate the political challenges that lie ahead. It's been a pleasure to co-author this book with so many distinguished academics and practitioners. It's a great pleasure, and also I'm grateful to Hart for actually giving us the opportunity to present this, which is much more of an academic work. And I believe that in the years to come, hopefully it will contribute to the debate. It will not define the debate, because the debate will go forever, but hopefully we will start posing some of the questions which need to be looked at in this book. On that note, thank you to everybody. It's a good sign that the participants dropping is that actually it's time to bring this to an end. And I've been noting last 5 minutes that the participants are dropping. So thank you very much, and we leave it there. And we thank you. Just want to remind you that we have another webinar on 15th of April on smart contracts in shipping and trade. And we look forward to seeing you there. Thank you very much. Have a good afternoon.
Thank you.